everyone. Welcome to this CLE event called Update on Employee Rights and Returning to Work During the COVID-19 Era. This is being run through the Beverly Hills Bar Association Labor and Employment Law section. My name is Nazgul Hashemi. I'm a co-founder and an attorney at Legal Access, Inc. I practice civil litigation and I provide general counseling to businesses at my firm. When I practice employment law, I typically do it on the plaintiff side. I also practice on the defense side when the employer does not carry any insurance. I'm currently a member of the executive committee of the labor and employment law section. And next year, I'm going to be serving as a vice chair on the committee. I have today with me here attorneys Max Gavron and Anand Matani. Max Gavron is a class action attorney at Diversity Law Group. This is a firm that protects employees' rights and promotes the interest of employees and litigation. Max and I actually went to law school together, and we were in the same graduating class at Southwestern Law School. And since then he's become an experienced and skilled litigator. Today, he's going to tell us about COVID cases in the class action context under the Labor Code. He's going to explore questions such as when employers need to compensate employees for matters related to COVID, including requiring testing for employees and working from home. We also have Anand Matani with us. Anand is an attorney and a founder at Matani Law Offices. This is an employee side labor and employment firm. I was actually introduced to Anand by another attorney when I first started practicing law, and I needed guidance on an employment case, and Anand was there to help me and allow me to reach a successful result. Anand is an experienced litigator with renowned creative strategies. Today, Anand is going to tell us about the legality of employers requiring vaccinations and whether there's any exceptions for employees and topics related to those issues. Before we get started, I want to give a special shout out to Tanaz Hashemi. She's the other co-founder and an attorney at Legal Access. She not only helped bring this event to life, but she also helped us prepare the materials. And so thank you, Tanaz, for that. You guys should have received materials about an hour ago. And in the materials, what you're going to find is a compilation of cases on the topics that we're going to be addressing here today. Anand also helped put together a list of laws for this, attendees to reference, and it also includes considerations related to tonight's topics. On page 72 of the materials, we also included a FAQ for COVID-related topics from government websites, such as the DFEH, the Department of Labor, the California Department of Industrial Relations, and other FAQs. So let's get into the topics for tonight. We're going to start in the class action context with Max telling us about an issue that he's been seeing come up regularly for employers. And basically what's been going on is that employers are requiring for their employees to undergo COVID testing before coming to work. And this is whether the employee is vaccinated or not vaccinated. And typically the testing is done off-site for safety reasons. And it's also after the employee has already clocked out and of the timekeeping tool or software that's provided by the employer. So Max, can you tell us what employers should keep in mind if they're requiring COVID testing and what kind of legal precedent you've seen that's related to this issue?
Sure. Thanks, Naz, for having me to talk about this stuff, and I'm happy to address those things. So, this comes up in the context of typically in production facilities, warehouses, things like that, where you have a lot of employees showing up typically at the same time at the start of a shift. Often what happens is there's not only COVID testing, but temperature check procedures. And because of the nature of the purpose of the COVID check, right, is if someone has a temperature that's higher than whatever the threshold is, you don't want that person coming into the facility and potentially spreading COVID to other workers. So prior to entering the facility, whether it's a warehouse, whatever it might be, a lot of employers are requiring temperature checks, at the gates or whatever it might be. Now that presents kind of a technological problem for the employer because it's difficult to get the employee to track their time and essentially get paid for that time. Now, from the employee's perspective, obviously they want to be paid for that time because they're subject to the control of the employer. And that's really the issue here, is whether the employees are subject to the control of the employer when they have to undergo these types of COVID screening procedures. In terms of authority that would be helpful to analyzing this situation, there was a series of cases that my firm worked on and I worked on over the last several years involving a different scenario, but very similar to what we're seeing now. And in that context, retailers often required their employees to go through what's called a security screening or a bag check. Typically, this would happen at the end of a shift where an employee has worked their shift at Nike or Ralph Lauren or whatever it might be, and prior to leaving their shift for the day, but after clocking out, employers were requiring employees to go through a security screening where they would check the employee's bag, see if they were basically stealing any merchandise. And the issue that was litigated through those cases was whether that time was compensable. And there are several cases that kind of address that I'm happy to talk about, Naz. Kind of starting, I guess, with the most recent. And that was a case against Apple called Furlecken, and that's from 2020. And in that case, it was a group of retail Apple Store employees, and there was a mandatory security check procedure where the employees were required to go through this screening but weren't being compensated for that time. Now, the California Supreme Court, on a certified question from the Ninth Circuit, analyzed whether that mandatory security check constituted hours worked under the applicable wage order. And it's important to think about, or when we're talking about these issues, it's important to remember that what I'm talking about is claims under the California Labor Code. If someone were to analyze this situation under the FLSA, it's an entirely different analysis, and there might be some other defenses that would be applicable. So ultimately, I think what it comes down to is whether the employer has control over the employee during the COVID screening, because you can see that the situation with those security check cases where the California Supreme Court has now held that it is hours worked and employers need to compensate for that time. It's analogous to the COVID screening procedures that we're seeing now.
So would this same analysis apply to the employer requiring the employee to get vaccinated? Is that considered some sort of compensable time because it's under the direction of the employer and the control of the employer, essentially?
I think the short answer is yes. I mean, again, you need to evaluate the level of control of the employer over the employee. If the employer is requiring that vaccination or requiring that process, then I think that the employer is obligated to pay for that time, including travel time. And if you look on the California Department of Industrial Relations websites, there's an FAQ, and they discuss this situation particularly, and they advise that employers should compensate for that time, including the travel time. And they even go a step further that if the employer requires the testing and there's expenses incurred there, they should also reimburse the employee for that.
Understood. So specifically for the California Labor Code, in that context, what kinds of defenses have you seen employers raise regarding this issue of compensable time? And what is wrong with those defenses from the plaintiff's perspective?
Sure. So this is another issue that came up and was litigated in all the security check cases that I worked on. And employers for a long time claimed that the time spent undergoing these types of inspections was de minimis. And there's a doctrine under the FLSA and that's applied in federal court that essentially says, if something takes such a small amount of time, employers need not compensate for that. And there was a case called Landers out of the Ninth Circuit that talked about that. Now, that issue kind of worked its way through the California court system. And in 2018, the California Supreme Court issued an opinion in a case called Troster versus Starbucks, and that's in the materials. And there, it was a similar question that we've been talking about today. And the court addressed whether the de minimis doctrine, as kind of worked out in the federal courts, was applicable to claims under the labor code. And the scenario, the facts there were employees at Starbucks basically doing post-shift closing procedures, pulling in the patio furniture, things like that. And ultimately, the California Supreme Court held that the de minimis doctrine did not apply to claims brought under the labor code, at least under those facts. Now, it's important. This is worth reading specifically what the court said. And this is a sentence that employers latch onto very often. The Supreme Court said, quote, "We do not decide whether there are circumstances where compensable time is so minute or irregular that it is unreasonable to expect the time to be recorded." Now, that arguably left open a question as to whether there's some remnants of the de minimis doctrine that could be applied to labor code claims. After that case, there was a Ninth Circuit case called Rodriguez versus Nike. And that was a case that our firm litigated and I argued at the Ninth Circuit. And the issue there, it was a security check case against Nike for these post-shift security inspections. At the trial court, the district court granted summary judgment on the basis of the de minimis doctrine. In the interim, the California Supreme Court had issued its opinion in Troster versus Starbucks. On appeal in Rodriguez versus Nike, the federal court analyzing Troster versus Starbucks essentially said, it's our belief, and we interpret Troster as limiting the application of the de minimis doctrine to claims brought under the California Labor Code. Now, in Rodriguez versus Nike, the employer argued that there should be some threshold where it doesn't matter, or employers shouldn't be required to pay time. They argued for a minute threshold, a 60-second threshold, and the Ninth Circuit rejected that. Now, I would say that, this is still, I guess, an open question because of what the California Supreme Court said. I mean, in my practice, I argue that it's not an open question anymore, but it's certainly something that's still brought up very frequently in these cases.
Understood. So it's something that we might see developing in the law over the next few years, potentially.
Yeah, and I would expect that it's something that's going to be litigated in the various cases that are pending right now with respect to these COVID screening procedures. We have some of them going, and I know that there are quite a few of them going right now.
So as a class action plaintiff's attorney, what is your suggestion for possible solutions so that employers can ensure that their employees are getting compensated for whatever time they spend under their control, essentially?
Right. So I think the simplest answer is to require these screenings to occur while an employee is on the clock and clocked in. Now, that can present problems because of some of the things that we discussed earlier with respect to, if you're at a warehouse and the time clock is inside the facility, but you're doing the inspection outside, obviously it's difficult to get employees to clock in first and then do the procedure. there's technology available that allows employees now to clock in from their phone. That presents maybe some other issues that we can talk about later, but that's one way to get around that. The other thing that I've encountered in some of the cases I'm working on now is employers will simply add time to employees' time cards, or based on how long they anticipate it to take, the security or the COVID screening procedure, that is. Now, that's obviously kind of a blunt tool to solve the problem, because you have to guess how long it'll take for that process. But I think that that's a good way to kind of get out ahead of some of these issues.
Got it. Well, if we do have time later, I would definitely love to hear the issues as far as checking in on the phone. So segueing, so we have this issue of compensable time, but we're also seeing issues in terms of reimbursable expenses with respect to COVID. So even with the vaccines rolling out, some employers are allowing or even requiring employees to continue working from home, whether that's full-time, some days of the week, some positions. So the question becomes, when employees work from home and they have to use their cell phones, their printers, the ink in the printers, their internet, and anything else that they really need to get the job done, what does the labor code say in terms of reimbursement for use of these items? When is reimbursement required, and what is the controlling authority on this topic?
Sure, that's a great question. Especially, most businesses are operating from home now. So this is a really interesting question. Labor Code section 2802, it's only a sentence, and it governs this circumstance. And it says, an employer shall indemnify his or her employee for all necessary expenditures or losses incurred by the employee in direct consequence of the discharge of his or her duties. So the question there becomes, what's a necessary expenditure, and what expenditures are a direct consequence of the discharge of the employee's duties? Now it's kind of interesting, because the public health situation has required a lot of employers to instruct their employees to work from home. So it's the employer, essentially saying, look, you got to stay home and you got to work from home and use your internet and your computer and your printer to perform the duties of your job. It's complicated because of the kind of public health aspect of it. But what I would say is that if an employee is required to use their cell phone or some other kind of tool for their job, the employer is required to reimburse that employee. Now, in terms of authority, there's conflicting authority, as there is in many areas of the law. But in looking into this a little bit, some of the interesting cases I came across, one of them is called Cochran versus Schwann's Home Service. It's from 2014. Now, what's interesting is that this case was actually on appeal from a class certification ruling. And so, the holding of the case is really focused on whether the class should have been certified. But in addressing that question, the court analyzed whether customer service managers who were not reimbursed for expenses pertaining to their personal cell phones, whether they should be reimbursed. And so in analyzing the class certification issue, it kind of framed the law and looked at Labor Code 2802. And it said pretty definitively that reimbursement is required for those employees, even if the employees are not incurring additional expenses as a result of the phone. So, for example, if I pay $50 a month to use my phone, regardless of the number of minutes, under Cochran, you would understand that you should reimburse that employee, even though their expenses don't incur. The obvious question is how much, and I don't know that I have a great answer to that question. Now, fast forwarding to 2019, the Court of Appeal issued an opinion in a case called Townley versus BJ's Restaurants. And in this case, it seems almost directly at odds with the holding in Cochran. But in this case, the issue was whether BJ's was required to reimburse employees for slip-resistant shoes. The employer required employees to have these slip-resistant shoes as a safety measure. And the Court of Appeal ultimately held that reimbursement was not required for this. And in holding that, it relied on a Ninth Circuit case that analyzed whether the employee could use that tool, in this case, the shoes, whether it had general applicability in the business. So, for example, if you have, black pants and they're required, that's something that you can use at a different restaurant gig. And so the court basically held that because these slip-resistant shoes were not a necessary expenditure for this particular job, they didn't need to be, the employees didn't need to be reimbursed for that.
Interesting. So it seems that we have these two decisions that overlap in some way, yet are somewhat consistent. So how would you reconcile these two holdings? What would you recommend for employers to do when it comes to reimbursing employees for something that's used on the job, whether we're talking about internet or a slip-resistant shoe?
So with respect to the inconsistency between the opinions, the easy distinction, and the one that I think most employers would make, if you're litigating this issue, is that the Cochran case was a class cert decision, and it doesn't have anything to do with what Labor Code Section 2802 actually requires. From a practical perspective, I think that employers would it would be advisable to reimburse employees for expenses that are incurred in performing their duties. It really is, I think, an open question, kind of how far that obligation goes and how much. Those are the tough questions that I think need to be answered on a case-by-case basis.
Got it. So I do want to ask you about class certification if there's time at the end. But for now, I'm going to move on to Anad's portion because I do want to hear from him as well. Thank you so much. That was very helpful. Okay, so Anad, so I want to segue into talking about vaccination requirements. And as we're seeing in California and really all around the nation, many employers are requiring their employees to get vaccinated before coming into work. And the question that many people have is this legal? Is it okay for an employer to mandate vaccines? And if so, is there any sort of exception for employees?
Well, I'm not sure there's any definitive guidance, but the DFEH and federal agency authorities such as the EEOC, Department of Labor, indicate that that would be okay, that requiring vaccinations generally is okay. They don't say it's limited to hospitals, just generally that's fine. However, they also explain, those three agencies, that antibody testing is not allowed, while virus testing is allowed. In terms of exceptions, you could probably dream up many, and I'm sure people will dream up many. We'll talk later about a case where they really dreamt up some interesting ones. But all of these agencies, specify, warn that you still have to follow FEHA, you still have to follow disability accommodation laws, religious accommodation laws, Title VII, ADA. So that could be an exception if a reasonable accommodation for an employee is no vaccination.
Got it. So a reasonable accommodation for a disability or a religious, a sincerely held belief. In the context of disability accommodations, what kind of information does an employee have to give to the employer during what we all know is the interactive process? What is the standard really that the employee needs to show to the employer to get a disability accommodation?
Well, if you're in California, the employee would need to get certification that they have some sort of condition or disability that limits a major life activity. That is not hard to do. Breathing, sitting, living, working are all found to be major life activities. So if you can go to the doctor and the doctor is willing to say that any one of your major life activities, which there are many, are limited, then there's a good chance that you can establish that you get accommodation. That is the same as any other disability outside of COVID or not related to COVID. But the one thing that you have here is in light of all of the agency noise and conflicting laws, you do have a lot of guidance from places like the FEH, Department of Labor, DIR, which is OSHA. And it might, if an employer really, does or does not want to provide an accommodation, looking at that guidance could potentially be a good prophylactic measure, because if the employee later decides that that you didn't do enough, at least you can reason why you did what you did. Also, in 15 years or so of employment law practice, I've never once actually seen anyone engage in an interactive process. I've seen that employees will request something and then they'll get a yes or no answer or there'll be some back and forth over email. But especially because these are, new and difficult times, if employers really don't know what to do, they can invoke sort of the solidarity of the, early days of the pandemic, where really, really mean and nasty opposing counsel were asking if, there's anything they can do for me, if they can bring me something. So, if employers are willing to really work with an employee, and even if they find later that there's nothing they can do, I think courts will notice that, and it will probably go a very long way.
Understood. So this analysis that you just gave, we're talking about vaccination requirements. Now, would the same, answers be present in the context of requiring a mask, employers requiring their employees to wear masks, meaning it's okay to mandate that, but of course, an employee can try to get some sort of accommodation through whether disability or religious belief?
Yes, that would be the same analysis.
Okay, great. So you put together some hypotheticals for us. So I want to present them, and then you can tell us what you think in terms of what an employer should do. So first hypo is where we have employee X, and she says that if she gets vaccinated, she's going to die. And so she needs a disability accommodation. On the other hand, we have employee Y, and he says if he gets COVID, he's going to die. So he needs a disability accommodation of being in a workplace where everyone is vaccinated. So what should an employer do if presented with these two employees? And how does an employer balance the interest of these employees without potentially violating the law?
Well, first, I think, it seems like a very difficult scenario. It could happen, actually. I wouldn't be surprised if it starts to happen with even some frequency. But, if I'm in court against an employer and the defense attorney gets up and says, Your Honor, we, Mitani's basically telling you that we're required to provide a risk-free workplace. And, that doesn't make a whole lot of sense to me. I mean, I wouldn't like our chances, but it's not necessarily true that an employee, both of these employees would be asking for something like that. I think, again, instead of looking at it as a very rigid thing, it really would depend on the facts. And if you can, kind of invoke the solidarity of the beginning of the pandemic and work with these people, then do it. And if you can't, my sense is that in a blue state like California, you should err on the side of protecting life first, but then also protect people's livelihood if you can.
Okay, so what about a situation then where an employee complains that a mandatory vaccination requirement is a violation of her constitutional right to privacy? And then in response, the employer moves her to a different department where vaccination is not required. Does this count as some sort of adverse employment action, or what kind of legal issues does this kind of scenario present?
Well, you're exactly right. I mean, depending on the circumstances, it could be argued that, it's an adverse employment action. To use a hyperbolic example, let's say, you work at O'Melveny and you're a tax lawyer, third year tax lawyer, and you don't want to be around the tax group, or, whatever. And so they move you to the labor and employment group. Well, that's a completely different thing. And you're just because you moved, that changes the trajectory of your career. So I think that this might, and even in the more factory or blue collar context, there could be scenarios where it's really sort of punitive or changes someone's conditions of work sufficiently that it is an adverse employment action. So, you don't want to be in a situation, I think, as an employer where you're saying no good deed goes unpunished. And, be very careful. It might, in certain scenarios, be better, to just explain why you're not willing to, change your view of vaccination.
And then would it kind of be the same analysis if the employer tells the employee, okay, well, you know what, if you can't get vaccinated for whatever reason, then you just stay home. You must work from home still. Whereas everybody else is coming into the office at that point. Does that present some sort of issue?
Yeah, I think it's it's potentially a very similar analysis. Going back really quickly to that privacy thing, note that, I don't think that there's any right to privacy that has been established that relates to mandatory vaccination, but there are various rights to privacy, as everyone knows, in constitutional law, statutory law. And, if it may be argued successfully by a plaintiff's attorney that even though there was no violation of a right to privacy, that there was that belief, and that belief sort of made sense. I mean, it makes enough sense for us to get New York Times push notifications about it. So it might make sense, otherwise. So your second question, I think, is similar. I think in the protected category in the first question might have been the complaint about a potential violation of the law. In the second one, it might be, well, if you don't have to necessarily accommodate every employee that doesn't want to get vaccinated. But again, you have to think about FEHA and similar laws. So if that person is articulating, that they have a need for accommodation under those laws, then again, I think you have to work with them, and it's not necessarily true that having them work from home is the best option.
Can you describe a little bit this concept of undue hardship, and basically when an employer is not really required to provide an accommodation, even if a disability or religious belief is established?
Well, I mean, generally speaking, it is a question of fact, and when it most often comes up when it has to do with, like, how much money it would take to accommodate someone. And, it's very difficult for big corporations, for example, to say that they have an undue hardship. But in this situation, I think it's untested. It's a question of fact. Different juries, different judges might look at the situation differently. But again, if you engage in an interactive process, if you out-reasonable the other side, I think that will really help should there be litigation, and it'll probably prevent litigation.
Got it. Thank you. So a while ago, a little bit before when you started, you referenced the Texas case, which everyone has been seeing coming out. It's the Bridges versus Houston Methodist Hospital case. And can you tell me explain for everyone what happened in that case? I know the plaintiffs were arguing wrongful termination, if they were fired for refusing to get vaccinated. But what happened in that case exactly? And what kind of answers in terms of the law did it tell us?
It told us nothing. So when, again, I was talking about New York Times push notifications because I got a New York Times push notification indicating that a Texas district court has held that vaccinations don't violate a right to privacy or something like that. Well, that's not really, that's pretty vague, and that's not really what happened. Actually, the arguments that were being made, well, just take a step back. In Texas, if we were practicing labor and employment law, whether on the defense side or the plaintiff side, we'd likely have a lot less money because they have a lot less protection for employees. For example, as was relevant in that case, wrongful termination in Texas means one thing, and all it means is that you're being asked to do something illegal and you refuse to do it. So the theory in that case was that the people who were being, subject to mandatory vaccination were being asked to do something illegal. That was sort of the primary theory. And the judge did not buy it. That's an understatement. The judge had no problem ridiculing it because the judge didn't understand what the illegal act is that they're being required to do. And they also had some other theories about violation of federal law. That the mandatory vaccination by that there was a hospital defendant violated federal law. The theories were that there were certain regulations that were violated, but those regulations the court held had nothing to do with the private employer and what it must do, but rather dealt with the government. And I'll have sort of an outline of that case in the materials, and it's a very short order. I wouldn't even say case. You can read it, but it's clear that, they might as well have, alleged that's a violation of, they might have alleged that it's a violation of the Nuremberg Code because they did allege also that it's a violation of the Nuremberg Code to have mandatory vaccination. And that was counterproductive. I don't think that the judge was very impressed. And that does not mean, however, that, somebody else, some other plaintiffs will come up with some arguments that the court might find compelling. For now, though, I don't think it's fair to say that because of that case, we have any guidance on what, a court might do if, someone like Chemerinsky or someone else really comes up with something much more interesting.
Got it. So really in that case, the issue is that for wrongful termination in Texas, it's a very limited claim. The employee needs to show that they were refusing to commit some sort of illegal act. Whereas in California, our wrongful termination cause of action is much broader. Can you explain what a wrongful termination cause of action in California looks like?
Yes. So a wrongful termination cause of action generally, is one where you can identify a California public policy, which means you can identify a state, federal, local law, regulation or law that is being violated by your termination. Most often in practice, what you see are discrimination or retaliation based on discriminatory acts and complaints or violations. Complaints about violations of the labor code or safety issues, but it can really be anything. If you complain about, as I tell my potential clients, you can complain about DMV stickers on your on the company car not being, up to date. And if you complain about that, and you find yourself in a bad situation, then that could be wrongful termination. Or if you're forced to participate in something that would violate statute, that could be wrongful termination.
Got it. Thank you so much. So really, like you were saying, the Texas case doesn't tell us anything about what would happen in a similar California case. Is that correct?
It doesn't tell us what would happen in a similar California case. It could very well be that there's no wrongful termination hook in California either, even though it's very expansive. But the hook can't. I mean, there are, basically every law is at play in California to some extent. So I could see someone dreaming something up, and I don't think that the Texas, if the Texas case were cited, I don't think it would carry much weight in that situation.
Understood. Thank you so much, Anad. That was extremely helpful. Max, do you have any thoughts that you'd like to give us following up to this discussion that we had with Anad right now?
I think something that's kind of universal to everything that we've talked about so far today is that when we're put in new situations in the law and as a society generally, we're presented with more questions than answers. And I think that, where this is going to end up is going to take some serious time. And hopefully by the time we figure it out in the legal world, what's required of employers and employees in a pandemic, we won't have to deal with it anymore because we'll have figured out the pandemic. But, who knows?
Great, thank you. So I do want to come back to what we were discussing with you in the class action context. And what kind of challenges are you seeing with class certification in California? So what I mean by that, I know that for certification, you need a well-defined community of interest amongst the class members. There needs to be predominant questions of law or fact and representative with claims typical to all of the class members. So in the context of compensable time for employees or even reimbursable expenses, what are some challenges to getting certified as a class?
Sure. I think the challenges arise where there is not a universal policy that's applied to the entire workforce, or at least a subgroup of that workforce. From my perspective in bringing these kinds of cases, what I'm looking for is some sort of written policy document that says, you're required to show up to get your COVID screening 15 minutes before work, and the time clock, is inside, right? That's a way that I can look at those documents and show objectively, look, we're going to present a common question for the court to resolve, in one fell swoop. Now, things get a little murky. Employers are typically raising things about, well, how long does it take? Everyone who goes through that screening, it takes a different amount of time. And those present kind of individualized issues that should be, that would require a series of mini trials. And, our retort to that from the plaintiff's bar is typically that those are issues of damages that can be resolved kind of on the back end once we've decided whether there's liability for this type of practice. And, something that's important to this kind of area of practice too is also the application of statistics to be able to articulate kind of a damages model that would show, what the exposure is, even if you're not actually going out there with a stopwatch and figuring out, how long each employee waits in line to get their temperature checked.
Got it. So really what you want to be looking for is written policies and data.
Yeah, I would say so.
Great. Anad, any observations or thoughts from you with regard to this issue of compensable time or reimbursable expenses, or even the class action context for any of that?
Yeah. So, I'm going to just speak a little bit above my pay grade for a minute, but I was thinking that this COVID mandatory vaccination safety, workplace safety, these scenarios, they really present an opportunity for, people who tend to favor, enterprise or management versus employees and the plaintiff's bar and the defense bar to really understand the other side. From what I understood from Max, you are totally darned if you do and don't, darned if you don't. And that is what I understand from the DFEH. And that's what I understand from, a lot of the materials that I am talking about, unfortunately. So it is a scenario in which if you are, like a hippie like me, you might say, well, this regulatory framework really does make it very difficult for employers to navigate in reasonable ways. On the other hand, everyone who's up in arms tends to, about, mandatory vaccination tends to be, usually on the more conservative enterprise leaning part of the scale. And they are angry, in my view, probably because you can't not work. So when there's a regulation that says in order to go to work, you have to put this needle in, you have to put this needle in your body and this liquid in your body, and you have no idea what the hell it is. They don't want to do that. And they think that it violates the Nuremberg code, So I think that they can start to understand perhaps that, that the other regulations too protect people because they really have no choice but to go to work. And I think that opportunity to understand is helpful.
Thank you. That's very helpful. This concept of the Nuremberg Code, can you describe that and just explain to our attendees what that is?
Yeah, that is truly above my pay grade, but it has to do, with what the international regulatory framework that came into existence after World War II, and especially relating to the Holocaust. So when you talk about it, in cases, you better have very, very clear arguments about it. Otherwise, you might look like you are just reaching quite a bit.
Got it. And so in that Texas case, they were arguing it was the mandatory vaccines violated the Nuremberg Code, and the court just did not entertain that argument at all. Is that correct?
I think the court enjoyed herself in putting it down.
Got it. All right. Well, any other observations, thoughts, or comments by the two of you before I turn this over and allow for the question and answer period to open up?
Nope.
I'm ready for questions if there are any.
Okay, let's see. So we have not sure if it's question or comment, but don't know about being done with the pandemic all that soon, especially with all the vaccine resistance. LA County Health Department just reimposed public indoor space mask mandate effective 11:59 Saturday night. Right, so I'm sure both of you saw that as well, that masks are being required again on Saturday. So I think we kind of went over this a little bit, but in terms of, requiring masks in the workplace, if somebody can show a disability or something related to not being able to breathe and it exasperates an underlying condition that they already have, then how is an employer supposed to treat that?
So I think that, again, it has to be a reasonable accommodation. There are a bunch of, defenses to claim for accommodation that basically also just mean reasonable. And so let's say in one scenario, a person runs like a clothing shop and, there's one person that's running the clothing shop and that one worker doing it at a time. I think that you're going to be able to find a reasonable accommodation. In a hospital, of course, it's going to be harder. So I think that, it's a difficult situation. It's sort of going to be a difficult decision, but I do think that the breadth of all sorts of agency authority should help fashion that.
One thing I would add too, just kind of looking at some of the problems we're facing more generally is, I know, we're a bunch of lawyers talking about this, but maybe we need to look, to other places to solve some of the issues, especially that I was discussing with respect to compensable time and everything. Because, technology, for example, in the COVID screening line discussion we were having, you really can have someone just clock in on their phone nowadays, and almost do away with that problem entirely. Now, with respect to the kind of second part of our discussion, you would have to reimburse that employee for using their personal phone, as a part of their job. It's interesting. This isn't entirely related, but I spoke yesterday. My sister's boyfriend called me, and he works for a company that has a time tracking device on their cell phone. He was asking me, just thinking about this right to privacy issue. The app that they use has location services, and apparently the location services are like pinging his phone on the weekend after he's clocked out. He's asking me, what can I do about this? Is this okay? And I mean, it's kind of a sidebar conversation, but these problems are not easy to solve, I think.
No, definitely not. That's very interesting. The location issue and it being pinged, and the employer basically knows at all times where the employee is. Is that what's going on?
I mean, who knows who's looking at that data? Facebook knows where you are at all times already anyway. So it's just, I don't know. It's an interesting kind of time that we're living in, I guess.
Definitely. So we have a question here. Is there any difference in application of the laws to private versus public entities?
I would say that there has to be in general, but how that relates to mandatory vaccination, I personally wouldn't be able to tell you. I would imagine that it's not going to be very different, given what appears to be a strong public policy articulated for the need of such vaccinations, and guidance from various agencies that say that it's fine to require vaccination.
Max, go ahead.
Oh, I was just going to say, I'm unsure what the potential customer would even sue the retailer for just telling them to put on a mask. I'm not even sure. I mean, I understand, if there's a lawsuit, you got to defend it, whatever, however viable it is. But I mean, I think, if you're subject to civil penalty for not complying with those regulations, it seems like that's what you got to comply with. I'm not sure.
Yeah. So I think this kind of goes to a question we have in the chat right now. A client of mine who owns a retail store was fined for not enforcing masks, but the client is concerned about potential lawsuits from customers if the store asks customers' medical record to not wear masks. What's the solution? How do you comply with the Department of Health requirements and avoid lawsuits? And I think that's really what Max was saying. It's hard to avoid lawsuits. I mean, you can give the best advice that you can, but overall, just avoiding a lawsuit, that comes down to the person who wants to sue. But what are your guys' thoughts on this issue as to what's the solution when you're faced with this, the client, the store gets fined, but the client is concerned. How do we deal with that as attorneys? What kind of advice do we give?
I see now that there was this additional comment that the law exempts people who cannot wear masks medically. So I think what I'm understanding is that there are some folks who come into the store who may have a medical condition and don't want to wear the mask. But how do you comply with your obligations to enforce mask wearing? I mean, I don't know that I have a great answer to that question. I think, we can see what the state has done in its kind of regulation of this issue is it's an honor system, right? And I mean, I think as the store owner, maybe you have to have a policy that says, look, if you don't have a medical condition, you need to wear a mask. But I don't know that there would be an onus on the retailer to check the customer's medical records to confirm that. I mean, the state doesn't even do that. But again, I'm not entirely sure about that.
Yeah, these are difficult questions because, especially because what we're dealing with is just still so new to us. I mean, we've all been in the pandemic for a year and a half now, but these legal questions and these issues that are emerging, they're all very new to us. And, a disclaimer in general, and kind of I'm going to get into my concluding thoughts, and then I'll let the speakers give us their concluding thoughts as well. But tonight, we really spent time talking about the general principles of law and how they apply to COVID-19 in the employment context. But what we're seeing is laws changing, especially local ordinances. We see them changing weekly, sometimes daily, and they're evolving as more people are vaccinated, but also as there's more variants present and spreading. So while tonight the purpose was to give general information and have people be able to identify certain issues that come up in terms of working from home, getting vaccinated, exceptions, I do encourage all the attendees and anyone listening to go look at the specific laws that affect your county and or city before you make any decisions or give legal advice to anybody. Because like I said, it's just ever evolving and it's changing almost weekly, daily. So it's important to do research and make sure you're informed before you get out there and start giving some legal advice, because what may be good legal advice this week might not be good legal advice in a month. So I encourage you to do your due diligence in that respect. And I'll go ahead and turn the floor to Max and Anad to give me their concluding thoughts as well.
Well, okay, so I think I jumped the gun on my concluding thought. So I'll keep it brief. But I think we talked about a bunch of different agency guidelines. Keep in mind that many of what an agent, what might appear to be a guideline or a law might just be some musings, and it may not really be accurate. I mean, I looked at the DFEH website and it didn't seem totally accurate to me, actually. So, just be careful with your clients, I would say. Don't just, point there.
Thank you, Anad.
Yeah, I think that's great advice. There's plenty of agency guidance that the courts aren't beholden to. In the wage and hour context, the DLSE has an enforcement manual that has a lot of interesting stuff in there, but it's not binding, and the California Supreme Court finds differently all the time. My kind of concluding thought is this is a very interesting area of the law generally, but then kind of throwing in this wrench, it makes it even more interesting and difficult to resolve. In kind of preparing for this, I was just bonking around on the internet and came across a survey that surveyed corporate employers, and in 2019, $2.64 billion was spent on class actions, and in 2020 it was $2.9 billion. And the survey attributed a lot of that increase to COVID and trying to figure out how to work our way through that. So I would just say, thanks to Naz and to Naz for having us tonight and putting this on. I think it was very exciting.
Thank you so much.
Yeah, thank you guys both so much for being here. Thank you for your time and helping bring the event to life. Tanaz and I both very much appreciate it, and I know the attendees do as well. And thank you to the attendees for joining us here tonight. Your MCLE certificates are going to be emailed to you within 24 hours. And again, you should have received the materials about an hour before we started. If you didn't, contact BHBA, they'll send it to you. You could feel free to email me to get the materials, or to just ask me my thoughts, tell me your comments. And yeah, that's it. Thank you so much to everybody, and we wish you all a great night.